The Executive Overreach Task Force will come to order. Without objection, the Chair is authorized to declare recesses of the task force at any time. And I recognize myself for an opening statement. Today's hearing of the Task Force on Executive Overreach will focus on the delegation of regulatory authority to an unaccountable federal bureaucracy. Since the 1960s, the portion of the federal budget dedicated to federal regulatory agencies has grown dramatically. Not only does Congress delegate vast swaths of lawmaking power to federal agencies, but there's been a great rise in additional ways Congress, the President, and the federal agencies have deviated from the traditional process of lawmaking, thereby diffusing responsibility for policies in complicated ways that few people can even begin to understand. For example, Congress has passed overlapping delegations of regulatory power to multiple agencies. That allows a bevy of federal regulators to bring simultaneous enforcement actions against Americans and American businesses, pressuring possibly innocent Americans to settle with them and comply simply to avoid the vast expense of fighting several federal agencies at the same time. And that's not to mention conflicting regulations, that both of which cannot be complied with. Further, more than 1/3 of major federal rules have been promulgated without prior notice and comment by the public, which deprives the American people of any opportunity to weigh in on how new regulations might hurt them. The President now uses more executive memoranda and blog posts for major policy shifts. Controversial issues are also outsourced to boards and commissions, as happened with the new Medicare cutting board created by Obamacare. Regulations also impose de facto by the issuance of federal agency guidance that, while technically not binding, nevertheless tells Americans how their federal regulatory overlords are interpreting the law, and that Americans should comply immediately or risk an enforcement action against them brought by those same agencies. An egregious example of just this happened days ago. The Department of Education and the Justice Department issued guidance claiming all public schools will lose federal funding if they don't let anatomical boys use facilities formerly reserved for anatomical girls. As one of our witnesses today summarizes, it would be, and I quote, "It would be an understatement to say that the transgender guidance goes beyond what Title IX, which was passed in 1972, actually requires. If someone had said in 1972 that one day Title IX would be interpreted to force schools to allow anatomically intact boys who physiologically identify as girls to use the girls' locker room, he would have been greeted with hoots of laughter. OCR is simply engaged in legislating," close quote. These unorthodox practices have led to the type of legal uncertainty condemned by James Madison. In Federalist Number 62, Madison wrote the following, which is worth quoting at length. "It will be of little avail to the people that the laws are made by men of their own choice, if the laws be so voluminous that they cannot be read, or so incoherent that they cannot be understood. If they be repealed or revised before they are promulgated, or undergo such incessant changes that no man, who knows what the law is today, can guess what it will be tomorrow. Great injury results from an unstable government, and what prudent merchant will hazard his fortunes in any new branch of commerce when he knows not but that his plans may be rendered unlawful before they can be executed? What farmer or manufacturer will lay himself out for the encouragement given to any particular cultivation or establishment when he can have no assurance that his preparatory labors and advances will not render him a victim to an inconstant government? In a word, no great improvement or laudable enterprise can go forward which requires the auspices of a steady system of national policy," close quote. With James Madison's concerns in mind, I look forward to the hearing today, but I would point out that I started a construction business in 1975, and through the course of seeking to advance my professionalism, I found myself conducting seminars in multiple states, among other similar contractors similarly situated. I began asking the question, how many agencies regulate your trade? And I did that from state to state, and we came with a kind of a constant number. This is back in about, well, the late 80s or so. 43 different agencies had a voice on my construction business that regulated me, and that was consistent with many other companies. We came to essentially an average consensus of 43. And so I wondered what I'd actually done to my oldest son when I sold that business to him. There are more agencies today that regulate him. It's impossible to know even all the agencies that regulate your business, let alone know all of the regulations, statutes and regulations that regulate businesses. So I would submit this. Not one business in America has a banner on their home page stating, "Notice, we are in compliance with all government regulations, conflicting or otherwise," close quote. You will not find that on anybody's website, because we know what would happen if you once bragged about being in compliance with all regulations. Regulators will show up to prove you wrong, and over time your profit margin goes into the red, and eventually you will no longer be in business if we unleash all of the regulators that are available to be unleashed on our businesses in this country or on our people. So I look forward to the testimony, and I would yield back the balance of my time and recognize the ranking member, Mr. Cohen, for his opening statement.
Thank you. I appreciate it. I didn't listen to as closely maybe as I should have, and I wasn't sure. What was James Madison's position on transgendered?
It was you label your own bathroom.
It was, but did they even have that back then? That's a great thing about our Constitution, is it can adjust and change with the times and what needs to reflect the current situation. James Madison probably didn't have much of an opinion on it. But this is something we've heard a lot about, and when I was ranking member of the subcommittee on regulatory reform, commercial and antitrust law, most of our hearings were devoted to anti-regulatory themes. A lot of talk about critical of regulation by unelected bureaucrats and a lack of political accountability. We considered various measures that would have added numerous unnecessary and burdensome steps to the rulemaking process, throwing whatever we could into the wheel to stop it. There was the recommendations to expand the authority of the Office of Information and Regulatory Affairs, OIRA, require ongoing retrospective review of all agency rules, and impose new rulemaking requirements on guidance documents. All these measures were to stop the agency's actions. An important point that gets lost in all this is that Congress created the agencies, delegated broad authority to the agencies, and Congress funds the agencies. So if Congress does not approve the direction of the agency action, it can always rescind or limit the scope of the delegated authority. It can also restrict funds for the implementation of specific rules that it disapproves of. And the fact is, it can, the opponents of regulation often do not have the votes to achieve those ends through the legislative process, so instead they try to raise issues and rhetoric and propose changes that would muck up the process. Most of the protections that are provided through regulation are popular. Most people like clean air and clean water, fresh air. It's a nice thing. They like the fact that the traffic is, especially in the air, is controlled in such a way that planes don't crash into each other regularly, because we've got air traffic controllers. So people like that thing. Regulations and broad agency authority that are necessary to craft those regulations are critical for public health and safety and protecting consumers from fraud and stopping unlawful discrimination, among many other things. Workplace safety, the Bureau of Labor Statistics reports in its 2014 census of fatal occupational injuries that there were 4,821 workplace deaths in 2014, the most ever reported. And so a lot of those regulations are intended to make the workplace safer. And maybe could have helped some of those 4,821 people no longer with us. According to researchers from the National Institute for Occupational Safety and Health, the American Cancer Society, and Emory's School of Public Health, there are an estimated 50,000 to 70,000 deaths from occupation-related diseases in the United States annually. Why is it we have agencies that develop regulations? As the Supreme Court has recognized, Congress's delegation of authority, the executive arises from the practical recognition our society and our economy have become far more complex and problems far more technical than in the late 18th century at the time of the founding and at the time of James Madison and his inability to address the issue of which seems to be the issue du jour in the scope of getting the American people aggravated about something that doesn't rise to a major level of aggravation with most people because they didn't even know about it, James Madison. Congress sets broad principles into statute and leaves it to the agencies to carry out the statute in conformity with those principles. This process has worked well to protect millions of Americans from a wide variety of harms, enhance innovation and economic growth, and ensure basic fairness and justice. And Congress retains ultimate legislative authority over agency action, ensuring democratic accountability. I thank the witnesses for the participation in today's hearing. I welcome your testimony and yield back the balance of my time.
Thank the gentleman from Tennessee, and now yield to the chairman of the full committee, Mr. Goodlatte from Virginia.
Well, thank you, Chairman King, for convening this fifth hearing of the Task Force on Executive Overreach, this one focusing on executive overreach in federal regulations. Federal regulations take a huge toll on small business. Warren Meyer, the owner of a company who runs campgrounds, said recently, "In 1 year, I literally spent more personal time on compliance with a single regulatory issue, implementing increasingly detailed and draconian procedures so I could prove my employees were not working over their 30-minute lunch breaks than I did thinking about expanding the business or getting new contracts." On a larger scale, a Mercatus working paper concludes that had regulation been held constant at the lower levels observed in 1980, the economy would have been nearly 25% larger by 2012, meaning regulatory growth since 1980 cost $4 trillion to the American economy in 2012, or about $13,000 per person in that year. The U.S. economy has generally also grown less dynamic over time, as the number of firms less than a year old as a share of all firms has declined dramatically, hampered in large part by regulatory burdens. Recently, and for the first time, the number of firms folding exceeded the number of firms created in America. It's no surprise, then, that the growth in startup company employment has also declined significantly over the last few decades. Surveys of small business owners show a steady rise in the ranking of government requirements and red tape as a most important problem. And this has contributed to American companies having to move overseas to thrive. In a 2011 survey, Harvard Business School alumni were asked about 607 instances of decisions on whether or not to offshore operations. Of the reported results, the United States retained the business in just 96 cases and lost it in 511 cases. Research shows that the loss of jobs to overseas markets results in higher unemployment, lower labor force participation, and reduced wages, which in turn increases the demand for spending programs for those who are negatively impacted, making our fiscal crisis even worse. More regulations also means higher prices generally. For example, since the once heavily regulated airline industry was deregulated in the 1970s, inflation-adjusted domestic airfare prices have fallen dramatically. Overall, while the cost of things the federal government regulates have soared, such as education, health care, and child care, the costs of things the government generally doesn't regulate have declined, such as clothing, cell phones, personal computers, and televisions. The way federal agencies operate also makes it very expensive for people harmed by their regulations to challenge them in court. As Professor Gary Lawson has written, consider the typical enforcement activities of a typical federal agency. For example, the Federal Trade Commission. The Commission promulgates substantive rules of conduct. The Commission then considers whether to authorize investigations into whether the Commission's rules have been violated. If the Commission authorizes an investigation, the investigation is conducted by the Commission, which reports its findings to the Commission. The Commission's complaint that a Commission rule has been violated is then prosecuted by the Commission and adjudicated by the Commission. If the Commission chooses to adjudicate before an administrative law judge rather than before the Commission, and the decision is adverse to the Commission can appeal to the Commission. If the Commission ultimately finds a violation, then and only then the affected private party can appeal to an Article III court. But the agency decision even before the bona fide Article III tribunal, possesses a very strong presumption of correctness on matters of both fact and law. That's not a recipe for freedom in America. That's not a recipe for success in America. That's not a recipe for job creation in America. I look forward to hearing from all our witnesses today about the growth in federal regulatory burdens imposed by an increasingly unaccountable federal bureaucracy. Thank you, Mr. Chairman.
I thank Chairman Goodlatte for his opening statement and now recognize the gentleman from Michigan and ranking member of the full committee, Mr. Conyers.
Thank you, Chairman King. Members of the committee, distinguished witnesses, and those who are attending the hearing in person, today's hearing is the 32nd anti-regulatory hearing that we have had since the beginning of the 112th Congress. The anti-regulatory fervor of some in this legislature is no doubt passionate and heartfelt. But as I have noted during the 31 previous hearings that we've had on this topic, regulation is vital to protecting everyday Americans from a myriad of harms. And broad agency authority is crucial to ensuring a well-run regulatory system that promotes public health and safety while providing certainty for business. So as we consider our witnesses' testimony, we should keep the following in mind. To begin with, the broad delegation of authority by Congress to administrative agencies is constitutional. During our first task force hearing, we heard testimony from some witnesses that called into constitutional doubt the entire notion of Congress delegating authority to an executive branch agency. It is true that the Constitution provides that all legislative power is vested in the Congress and that Congress cannot completely delegate this power. The Supreme Court, however, has recognized that the Constitution doesn't prevent Congress from obtaining the assistance of the other branches of government. In fact, as the court noted in Mistretta versus the United States, its decisions in this area have been driven by a practical understanding that in our increasingly complex society, replete with ever-changing and more technical problems, Congress simply cannot do its job absent an ability to delegate power under broad general directives. That recognition, in turn, highlights the central role of regulation and of administrative agencies in addressing a broad spectrum of harms in our modern society. Without question, regulations provide critical protections, such as ensuring the safety of the water we drink, the air we breathe, the food we eat, the cars we drive, and the places where we work. These matters require highly technical expertise and sometimes years of study in order to address properly. After all, how many House members have the knowledge and the time to determine exactly how many parts per million of carbon monoxide would be acceptable to ensure safe air to breathe? How many senators are equipped to determine the proper amount of air pressure that's necessary to ensure that a train's braking system works properly? I would guess that the answer is probably not many, not too many. Finally, Congress already has at its disposal a number of tools to ensure due process and democratic accountability with respect to agency actions. Most obviously, Congress can always rescind or limit the scope of delegation if it so chooses. Congress also has the power of the purse to limit an agency's power or its ability to implement a rule. The fact that congressional opponents of regulation often lack the political support to do these things does not mean that checks do not exist. And so with these points in mind, I look forward to our witnesses' testimony, and I thank the chair and yield back.
I thank the gentleman from Michigan precisely to the second. And without objection, other members' opening statements will be made as part of the record. Let me now introduce the witnesses. Our first witness is John Graham, Dean of the Indiana University School of Public and Environmental Affairs. Our second witness is Sophie Miller, Senior Policy Analyst at George Washington University Regulatory Studies Center. Our third witness is Amit Narang, Regulatory Policy Advocate at Public Citizen. And our fourth witness is Gail Harriet, a law professor at the University of San Diego School of Law and a member of the U.S. Commission on Civil Rights. We welcome you all here today and look forward to your testimony. Each of the witnesses' written statements will be entered into the record in their entirety. I ask that each witness summarize his or her testimony in 5 minutes or less. To help you stay within that time, there's a timing light in front of you. The light will switch from green to yellow, indicating you have 1 minute to conclude your testimony. When the light turns red, it indicates that the 5 minutes have expired. Before I recognize the witnesses for their testimony, it's the tradition of the task force that they be sworn in. So I'd ask you please stand, raise your right hand. Do you solemnly swear that the testimony that you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. You may be seated. Thank you. Let the record reflect that the witnesses have answered in the affirmative. And I now recognize our first witness, Mr. Graham, for your testimony. Mr. Graham.
Thank you, Mr. King and members of the committee. I agree with the sentiments that federal regulation is an essential tool of government, and my testimony addresses the question of how to make it more informed and smarter based upon the available evidence and public opinion. I want to introduce as a theme the notion of stealth regulation. In the dictionary, the word stealth refers to secretive behavior and often like the sneakiness of a cat burglar. And I want to talk about regulators, how sometimes, not always, they engage in this stealth-like behavior. And it's something that I want to draw to the committee's attention. Now, how do they do this? They do this with innocuous-sounding actions such as guidance documents, official notices, policy statements, risk assessments, directives, enforcement advisories, and waivers for state regulators. All of these constructs are often useful and necessary for a good functioning regulatory system, but they can also be used to accomplish what would normally be accomplished through rulemaking. And sometimes they do this to avoid the basic protections that are provided in the Administrative Procedure Act for rulemaking. So, for example, today, some of the most controversial issues in regulatory policy are being resolved with stealth regulations. Civil rights policy at the Department of Education, coal mining permits at the Department of Interior and EPA, immigration policy at the Department of Homeland Security, Affordable Care Act policies at the IRS and the Department of Health and Human Services. So what are the process problems with a stealth regulation? The first is the basic concept of opportunity for public comment can be compromised, either because the agency doesn't seek public comment, they simply issue the guidance document, or they receive comments but are under no obligation to respond to the comments. In the rulemaking process, you have a legal obligation as an agency to consider and respond to those comments. The second problem with stealth regulation is that OMB and the interagency review process may be compromised. In rulemaking, those draft regulations go to OMB, and OMB shares those with all agencies in the government. They take comments, they pass that back. I worked 5 years from 2001 to 2006 at OMB OIRA, and I was in the midst of all that process. Now, these other types of processes may not involve either OMB or the other agencies, so you don't get the same vetting process inside the government that you would do normally. Third, requirements for cost-benefit analysis and small business impact analysis are applicable to rulemakings, but not necessarily to all these other actions. So you don't get the same kind of economic analysis and small business analysis when you allow these stealth regulations to evolve. And finally, the scope for judicial review of agency actions may be narrowed if it's not a rulemaking, if it's one of these other actions. Judges may be reluctant to intervene if there's not a robust rulemaking record that's been provided. And when you do these stealth regulations, you can often accomplish it without that big record. Now, there are some courts that are beginning to detect this problem and are striking down some of these regulations, de facto regulations, through stealth activity. I want to conclude and just give one small example. It's on an issue that we can all relate to, which is the growing interest in electric cars in America. And I happen to be a person who's interested in an electric car. I drive from Bloomington to Indianapolis. It takes about 60 miles. To get there and back, I need an electric car with a range of 120 miles. So the technology is getting better, but it's not quite there. But I'm interested in this. But what I find fascinating is that the state of California has actually required, through regulation, that 15% of all new vehicles will be electric or zero emission by 2025. 10 other states have joined them, so we now have effectively a third of the country covered by an electric car mandate. Now, I look closely at the history of this. Each of these electric vehicles could cost on average $10,000 more than the average vehicle, but they'll save the consumer some money, so there's an important cost-benefit question there. But the California analysis that supports this regulation only analyzes the regulation from California's perspective. It doesn't consider the impact on other states in the country. Meanwhile, California is not permitted to do this regulation unless they get approval from the EPA on a waiver authority under the Clean Air Act. EPA granted the waiver, but EPA never did a cost-benefit analysis on a national perspective. So here we have, through a combination of activities, a national regulatory program never been subject to a national cost-benefit analysis. Thank you very much. I look forward to the comments and questions.
Thank you, Dean Graham, for your testimony, and the chair now recognize Ms. Miller for her testimony.
Thank you, Chairman King, Ranking Member Cohen, and members of the task force for inviting me to share my expertise. Thank you also, Chairman Goodlatte and Ranking Member Conyers, for joining us today. I appreciate your attention to this issue. I appreciate the task force's interest in the rulemaking process, including in retrospective review and opportunities for Congress to improve it. I am Senior Policy Analyst at the George Washington University Regulatory Studies Center, where I analyze the effects of regulation on public welfare and evaluate regulatory reforms, including the success of current and past retrospective review efforts. Through my research, I've identified ways to improve these initiatives. Retrospective review is a bipartisan reform effort that can improve both the quality of existing rules and of future rules by learning what works well in a regulatory context and what doesn't. My remarks today include how retrospective review can be a powerful tool toward an effective regulatory process, how past and current reforms have fared, and ways to improve retrospective review to ensure that regulations are accomplishing their intended outcomes. Retrospective review is a form of program evaluation that reviews the efficacy of a policy, in this case, a regulation, after implementation to evaluate whether it has had its intended effect and whether it should be continued or revised. These reviews can inform policymakers on how best to allocate limited resources to accomplish broad social goals, like improved environmental quality or better human health through regulation. Retrospective review can provide valuable feedback and learning that improves the design of future regulations. While policymakers have the opportunity to revisit many federal programs each time federal funds are being appropriated, regulatory programs often exist in perpetuity without a statutory requirement to revisit them after the fact. Every year, federal agencies issue thousands of new regulations, but despite the pace of regulatory activity, regulators seldom look back at existing rules to consider whether they are accomplishing their goals and resulting in the estimated public benefits and costs. That's why President Obama in 2011, like presidents before him, directed federal agencies to review existing regulations and to, quote, modify, streamline, expand, or repeal them in accordance with what has been learned, end quote. Policies that apply retrospective review to regulations have a long history in the United States, dating back to the Carter administration and continued by every president since then. Despite 40 years of bipartisan reform efforts, agencies still do not conduct effective retrospective review of their rules. More recent efforts to encourage this review, such as the 3 executive orders issued by President Obama, have not resulted in a systematic culture of evaluation or large burden reductions for the regulated public. For example, an analysis I conducted of EPA's 2013 plan for retrospective review found that it did not include the unprecedented cost savings and burden reductions for the regulated public, which many observers had hoped for. Only 1/5 of the regulatory actions in EPA's progress report were expected to reduce costs, and a number of actions actually increased burdens on the regulated entities. One reason why agencies struggle to review the effects of their rules is because they don't design their rules at the outset to facilitate this measurement, despite existing recommendations from OMB that they do so. Writing rules to facilitate later retrospective review can ensure effective data collection and encourage regulators to clearly identify and think through how the proposed rule will address the policy problem at hand. In 2014, our team at the GW Regulatory Study Center examined high-priority proposed rules to see whether they included components that would help the agencies review their effects after implementation. We found that not a single rule we evaluated contained a plan for review, and most rules didn't contain any quantitative metrics that could be used to measure whether the rule was successful. Independent agencies scored particularly poorly on these criteria. This suggests that the current review system, while headed in the right direction, is not sufficient to create the right incentives for effective evaluation. Retrospective review is a key component of an effective regulatory review process because it allows agencies to review the effects of their existing rules and evaluate whether they are accomplishing their intended goals and determine what effect they have on the regulated public. Writing these rules at the outset to facilitate this measurement can improve regulatory outcomes and enable policymakers like yourselves to learn from what has worked and what hasn't. Thank you all.
Thank you, Ms. Miller, and I now recognize the gentleman, Mr. Narang, for his testimony.
Thank you. Chairman King, Ranking Member Cohen, and distinguished members of this task force. Thank you for the opportunity to testify today. I'm Amit Narang, Regulatory Policy Advocate at Public Citizens Congress Watch. Public Citizen is a national public interest organization with more than 400,000 members and supporters. For more than 40 years, we have successfully advocated for stronger health, safety, consumer protection, and other rules, as well as for a robust regulatory system that curtails corporate wrongdoing and advances the public interest. Public health and safety regulation has been among the greatest public policy success stories in our country's history. Regulations have made our air far less polluted and our water much cleaner. They've made our food and drugs safer. They've made our workplaces less dangerous. They've made our financial system more stable. They've protected consumers from unsafe products and from predatory lending practices. They've made our cars safer. They've outlawed discrimination on the basis of race and gender, and much more. Although these regulations are now considered to be bedrock protections widely popular with the public, it is important to keep in mind that opponents of these regulations at the time predicted economic doom and gloom if they were adopted. None of these predictions came true, of course, and this is an important lesson when considering current doomsday predictions from opponents of new regulations. In short, our regulatory safeguards are to be celebrated and emulated. Unfortunately, the state of our current regulatory system is a deep cause for concern. Our regulatory system is badly broken and in dire need of reform. The rulemaking process moves too slowly to protect the public, agency funding continues to stagnate or even decline, and the revolving door between regulated industry and federal agencies continues to spin, leading to industry capture of our regulatory system. Given the focus of this hearing, I will spend the rest of my time on the current crisis of regulatory delay. The sad truth is that nearly every major new piece of legislation that Congress enacts to protect the public takes far too long to result in regulations that actually do benefit and protect consumers and working families. Take these 4 laws passed on a bipartisan basis during President Obama's first term as an illustration. The Pipeline Safety Act of 2011, the Food Safety Modernization Act, the Family Smoking Prevention and Tobacco Control Act, and the Dodd-Frank Wall Street Reform Act. All of these laws were passed by Congress to protect the public's health, safety, and financial security. And yet regulators have taken, on average, 4 to 6 years to develop and put in place the important new regulations that implement and enforce each law. Astonishingly, 3 of the 4 laws still have not been fully implemented. For all of these laws, federal agencies miss statutory deadline after statutory deadline, as if those deadlines were optional instead of mandatory. It's the public that pays the price of regulatory inaction and delay. Pipeline leaks that pollute the environment and make neighborhoods inhabitable, increasing youth use of and addiction to e-cigarettes, continued reckless gambling on Wall Street, and frequent tainted food scandals. The unacceptable delays in implementing these laws are the rule, not the exception. As the breadth of these laws demonstrates, the crisis of regulatory delay extends across agencies and across regulatory sectors. The anecdotal examples are backed up by comprehensive empirical evidence of systemic regulatory delays. Last year, the conservative-leaning think tank, the R Street Institute, undertook a comprehensive study of how often federal agencies are able to meet the statutory deadlines when enacting significant new regulations. The results are deeply troubling. Regulators miss congressional deadlines a shocking 50% of the time over the last 20 years. What are causing these delays? The bulk of new regulations that are minor and technical in nature do not encounter significant delay. Rather, it is the most important regulations, sometimes termed significant or major, that provide Americans with the greatest benefits, but also take the longest to finalize. This is because the rulemaking process for these rules has become inefficient at best and dysfunctional at worst. When developing significant or major regulations, agencies are required to analyze not only the rule itself, but also multiple alternatives, even when alternatives are prohibited by statute. Agencies are required to conduct multiple cost-benefit analyses that are highly speculative, yet demand enormous resources. Agencies are required to conduct at least one, and often more than one, public comment period and respond to the hundreds or thousands of comments submitted by stakeholders. Executive agencies must submit their significant rules to OIRA for review, an increasing source of delay as OIRA reviews have taken longer under this administration than any previous one. Finally, all of these procedural requirements occur against the backdrop of a likely court challenge by regulatory opponents. As the saying goes, protections delayed are protections denied. A regulatory process that disregards statutory deadlines, vetoes congressional mandates on the basis of flawed cost-benefit analysis, and is generally unable to fulfill congressional intent in protecting the public should be a high priority concern for all members of Congress. This Congress has been interested in streamlining inefficient regulatory processes that result in undue delay, such as legislation passed last year to expedite energy and infrastructure permit approvals by stripping away environmental cost-benefit analysis, imposing hard caps on public comment periods, and sharply reducing the ability for stakeholders to bring court challenges. It is disappointing then to see Congress propose essentially the opposite reforms for public health and safety regulations, adding more cost-benefit analysis, longer comment periods, more OIRA review, and more opportunities for regulatory opponents to challenge in court. Congress can and should fix our regulatory process, and it's long past time that it does. This is the kind of congressional accountability that is needed. Public Citizen stands ready to work with lawmakers on both sides of the aisle to make our regulatory system work effectively and efficiently for consumers, working families, and the public. Thank you, and looking forward to answering any questions you may have.
Thank you, Mr. Narang. The chair now recognizes Ms. Harriet for her testimony.
Good afternoon, Chairman King, Ranking Member Cohen, and distinguished task force members. Thank you for this opportunity to testify on this important topic. I should note I'm here as an individual member of the Commission on Civil Rights and not on behalf of the Commission as a whole. I will be brief, though I should say that's not so easy since there's plenty to talk about here. I will thus be focusing my remarks on the Department of Education's Office for Civil Rights, though there are many other government agencies that would also be worthwhile to discuss. To put it plainly, OCR is out of control. Its pronouncements are in no way tethered to the actual law. OCR officials have shown again and again that they're not interested in what the statutes they're charged with enforcing really say. They are pushing their own agenda. Congress is supposed to be the one who makes the laws. Composed of the people's representatives, Congress is the one that's supposed to make decisions about policy. OCR is supposed to implement those. Somehow, our system of representative democracy is not working. The best, but by no means the only example, is the recently announced transgender guidance, requiring schools across the country to allow intact, anatomically male, that is, boys, who psychologically identify with girls, to share toilet, locker room, and shower facilities with actual girls. Congress intended no such thing when it passed Title IX back in 1972. That statute prohibits sex discrimination by federally funded schools, colleges, and universities, plain and simple. It makes an exception for separate living facilities, which was crystallized in a rule promulgated in 1975, which explicitly authorizes separate toilet, locker room, and shower facilities based on sex. Actual sex, not the sex we might desire to be. To claim that back in the 1970s that the 92nd Congress intended or that the American people understood Title IX to require schools to allow anatomical boys who view themselves as girls to use the girls' room would flunk the laugh test. Indeed, OCR doesn't even claim it. Instead, OCR's argument, insofar as it has one, is that it just noticed, surprise, that a 1989 Supreme Court case, Pricewaterhouse versus Hopkins, requires this result. Well, no, it doesn't. Pricewaterhouse concerned a woman who allegedly had not been promoted because she was perceived as too aggressive. The court reasoned that if a male employee with the same aggressive personality would have been promoted, that she was indeed discriminated against on account of her sex within the meaning of Title VII. Fine. But let's try that same line of reasoning in connection with the transgender guidance. Suppose a school had a student who is anatomically male, but who identifies psychologically as female. Would a female student with the same psychological identification be permitted to use the girls' room? Well, yes, of course. But that's very different from Pricewaterhouse versus Hopkins, because Title IX and its implementing regulations explicitly permit schools to, quote, provide separate toilet, locker room, and shower facilities on the basis of sex, close quote. More important, note that applying this line of reasoning proves too much. Consider instead an anatomically male student who identifies as male, that is, the more typical male. It is still true that if his female counterpart, an anatomical female who identifies as male, she would have been permitted to use the girls' locker room. Yet we know that schools are explicitly authorized to have separate toilets, locker rooms, and shower facilities for each sex. This takes the case outside of the Pricewaterhouse situation. Note that in my testimony so far, I haven't argued whether OCR's transgender guidance is good or bad policy. For the record, I think it happens to be bad policy, at least when it's shoved down the throats of schools, colleges, and universities. Far better to allow these institutions to make their own choices on these matters. You can ask me about the underlying policy issue in the question and answer period if you so desire, but right now my point is more limited. This is not what Title IX actually requires. OCR's actions are lawless. In my written testimony, I discussed a few ideas about how to get OCR and other agencies back on track. The simplest recommendation is stop giving them more money. Last year, the Obama administration asked for a huge budget increase for OCR. I wrote a long epistle to Republican appropriations leaders saying, please don't do it, and explained why. But Congress gave it to OCR anyway, not quite as large as the administration had asked for, but nevertheless very large. We are now experiencing the results of that decision. I have two somewhat more complex proposals in my written testimony, but I see that I'm running out of time, so I would be very glad to talk about those ideas during the question and answer period or with your staff after the hearing. The bottom line is that the framers of the Constitution knew that they had to structure the institutions they were creating to get the incentives right. That work did not stop with them. The incentives of administrative agencies have to be carefully structured as well, and I would urge this Congress to do that.
Thank you, Ms. Harriet, for your testimony and each of the witnesses. I now recognize myself for 5 minutes of questioning. I turn first to Dean Graham and ask you the question this way, that if you heard in my opening statement that no business, I suppose this to be true, in the United States has a banner on their home page that says, notice, we are in compliance with all federal regulations. Could you think that it's possible to be in compliance with all, just all federal regulations?
I don't know for sure, but I do know that colleges and universities are also heavily regulated sectors of the American economy, and we don't have any such statements on our websites that I'm familiar with.
And when you talked about some of the ways, guidance, notices, advisories, and could you speculate as to how difficult it might be just to be aware of all the regulations, let alone being in compliance with them?
Yes, it's a little easier with rulemakings and regulations because we have accounting mechanisms in the federal government to count them. But for these other types of stealth regulations, I call them, guidance documents, enforcement notices, there's actually no centralized method to even count how many there are in various agencies in the federal government as a whole. So it's very hard to get your arms around the magnitude and the trends.
Do you recall, it seems to me that I do, about a second or third tier U.S. Treasury webpage that issued a regulation on Obamacare 2 or 3 years ago? Does that ring a bell, Mr. Graham?
Well, I'm aware of several of them. The one was addressing the employer mandate and the delay in the employer mandate. And if you remember the context for a lot of that, obviously, quite understandably, the administration was trying to address a very difficult situation. But we insist upon the idea that when you're going to make changes in major programs like that, that you go through a standard rulemaking process. So it was a highly unusual situation.
Thank you, Mr. Graham. I'd turn to Ms. Miller. And in your testimony, you commented that President Obama, post-inauguration of his first term, directed a review to modify, streamline, or expand regulations. Do you have a judgment on what actually happened? Was there modifying, streamlining, or was it expansion that we witnessed?
That's a good question. So what we saw a lot of through the agency's progress reports is that they listed rules that they were already conducting and planning to conduct as part of their retrospective review programs. I don't know how many of those actions were initiated as a result of the executive order. I would guess that most of them they were planning to do already and decided to categorize as retrospective review so that it could look as if they were complying. But my research did find that many of these retrospective review actions did increase burdens on the regulated public, and that was as a result of recategorizing large rules, such as Tier 3, as regulatory actions pursuant to the President's executive order.
Thank you, Ms. Miller, and then turn to Mr. Narang. And in your testimony, you mentioned a likely court challenge by a regulatory opponent. That would likely be a business that was affected by those regulations. It seems to be the most likely. And can you tell me, if you're a business and there's a regulation that emerges in one of these unreviewed, unreviewed regulation that has the force and effect of law, and a business is disadvantaged by that, and they appeal through this process. Have you heard Chairman Goodlatte's opening statement about the convoluted way by which one seeks justice from outside the commission, I believe, was the language that was used in that, and you end up appealing back to the very agency that has issued the rule in the first place without an opportunity for a de novo review. How then does a person in America receive justice?
So the guidance documents, I believe, are the type of regulatory actions that you're referring to that could result in enforcement actions. I don't think that's a proper characterization of the legal effect of binding guidance documents. Guidance documents are not legally binding. Non-compliance with guidance documents can result in other types of sanctions. If, for example, an entity is receiving federal funding for compliance with the regulations.
But the question was about, without a de novo review, how does a person ever achieve justice if they're appealing back to the same agency that has created the regulation that they claim that the individual is in violation of?
Sure. So generally speaking, and I'll use the SEC and their administrative adjudication as an example, as a case study, but generally speaking, the rates for, essentially the rates at which litigants win within administrative adjudication tribunals and the rates that litigants win in Article III courts are roughly similar. In fact, sometimes agency tribunals result in increased rates of victories for legal
We
victories for
conclude that it's
litigants.
about as difficult as understanding how, and I think that my time is nearly out, but I'd like to ask a concluding question to Ms. Harriet, because you put the most provocative testimony out here in front of this panel. And I'm trying to, I don't really want to visualize this order that this directive that the president has issued, but the girls that are in the shower when the anatomically intact male comes in, how do they determine the gender of that anatomically correct male?
It's what he says it is. They're not, a transgender person is not required to provide.
Does that shock those girls any less?
I feel that the girls are going to be shocked regardless of what the evidence is of transgender status. One problem, though, is given that no proof is required, this causes a greater likelihood of pranksterism, of voyeurism, and such, because who's to challenge someone who says that they're transgender? Nobody's going to want to be in that position, and therefore we can expect to see some foolishness going on here. I think most schools have a great deal of sympathy for those who are in the transgender status, but by forcing these schools to engage in a one-size-fits-all, here's how we're going to deal with it, I think that's a big mistake. And for the Department of Education to do that, given that Title IX in no way requires this, particularly to do it through a guidance, is utterly inappropriate.
This turns, in my opinion, on the difference between immutable characteristics and mutable characteristics, and I think that's when we went down the wrong path. I thank all the witnesses, and I now yield to the gentleman from Tennessee for his 5 minutes.
Thank you, Mr. Chair. The American Association of University Women and Know Your 9, a group that powering students to stop sexual violence, have got letters I'd like to introduce into the record. The Know Your 9 particularly takes great exception to Professor Harriet's testimony and suggests that much of it is factually in error, let alone questioning some of her legal theories, and then the AAUW just as in general. So without objection, we'd like to enter these in the record.
Hearing no objection, so ordered.
Thank you. Ms. Harriet, you've got a phenomenal background, resume. You're obviously a very smart woman. I thank you for dedicating some of your work here to the Office of Civil Rights. You're on the Civil Rights Commission, is that correct?
That's correct.
Reappointed by President Obama?
No, I was appointed by the Senate. I am Senator McConnell's nominee to the
Oh, I see. What are some of the things that you have done on the civil rights, to promote civil rights?
What have I done to promote civil rights? Everything we do promotes civil rights.
What have you done? I mean, what have you done to help voting rights, for instance? Have you done things to help get people extend the right to vote? Because
The commission doesn't go out and register people to vote. What we
Well, I'm
do
hip
is
to
issue
that.
reports.
Yeah, and if you issued some reports that suggest that maybe some of the activities that have taken place in recent with photo IDs and other things might be barriers to voting, and tried to find ways to maybe suggest we should find ways to encourage people to give
I
the
don't think we've done one on voter ID in particular, but we have done voter fraud and voter suppression reports in the past.
Okay. And what are some of the things that you've found that has extended civil rights that maybe that your work on the commission has you've been most proud of?
Well, let's see. Most proud of? That's kind of a difficult question. I am quite interested in our eminent domain report that we did recently. I like that.
How about something a little bit closer?
We have a religious liberty report that's coming out soon that I think is quite a good report. I'd be very happy to furnish you with copies of those reports.
Religious liberty, is that, tell me what the perspective is on that.
It's a very complex subject. You don't want to spend your time on that. We go on forever and ever and ever.
Well, then thank you.
But absolutely, I will make sure that you get a copy as soon as it comes out.
Thank you. We've had, there's different perspectives on religious liberty, and some, see it one way and some another. I mean, it's all.
Yeah, our report is not limited to one aspect of it. Our report deals with lots of different aspects of religious liberty.
Mr. Narang, you suggested in your testimony that there are some problems because we don't get the rules adopted quickly enough. Is that because we don't have our budgeting process and we don't have enough people there, or is that the problem?
So some of it is, claims that the federal workforce has increased dramatically since the 60s. There's some needed context there. It's true that the federal workforce has increased. I think the GAO pointed out in a recent report that about over the last 10 years, 94% of that increase is DHS, DOD, and the VA. So the public health and safety agencies, the agencies that oversee and regulate Wall Street, they are not getting massive funding or staffing increases. And at the same time, they're getting quite a few more responsibilities with respect to public health and safety and financial security.
Thank you, sir. Ms. Miller, I want to congratulate you. I understand you just graduated, right? Did you just graduate? Get a
Sorry?
master's degree?
Oh, I have a master's degree, yes.
Did you just get it?
I did in May, thank you.
Good. Congratulations.
Thank you.
You in your report, there was something here about some of your work had to do with airline passenger protections. What airline passenger protections have we had lately? I mean,
I think in the report what that might be referencing, are you talking about my bio or about the?
Oh, it's in your
faculty
bio. It says that
testimony?
you've submitted public comments and establishing, among other things, airline passenger protections.
Yeah, generally what those were passenger protections for consumers, such as transparency in
Ticketing.
ticket purchasing and things like that, and other transparency measures for consumers while riding on airlines.
I got you. Nothing about getting seats a little bit more further apart.
No, sorry to say.
I thought I'd missed that if it was the case. Do you agree with Mr. Narang that we don't have enough money allocated to get these regulations approved quickly enough?
That's a good question. The GW Regulatory Study Center does an annual report that tallies the amount of money that's budgeted to federal agencies to conduct regulation, and we do find that the budget, adjusted for inflation, has been increasing steadily over time. So it seems that there are resources there. I think there are enough resources to be able to promulgate rules sufficiently. One issue that I've heard when speaking with regulators is that sometimes the deadlines that are established in statute are a bit ambitious, and it's difficult for them to conduct a very thorough analysis and make good decisions within those timeframes.
Thank you. And I don't have any time left, but I would comment that Dr. Graham has got a marvelous vitae as well. He's been praised by Senator Moynihan, and he had the wisdom to live in Santa Monica, so I can't really ask him anything. He's beyond.
The gentleman's time has expired, and I now recognize the ranking member of the full committee, Mr. Conyers of Michigan.
Thank you, Chairman King. And I thank the witnesses. I want to talk with Mr. Narang for a few minutes about the 2008 financial crisis that we're still coming out of. Was that a result of too much or too little regulation, or did it play any part at all?
Thank you, Congressman. Definitely too little regulation and oversight of Wall Street.
Mm-hmm. Anybody else want to venture a response to that question?
Yeah, I guess I would have said both, because we also had the problem of putting a lot of expectations on lenders to make loans to households and communities that were not in a position to actually pay back those loans. So those kinds of expectations, and much of that was in government policy, but not necessarily in formal regulation. So I would say both played a role.
Mr. Narang, some of your fellow witnesses at the table suggest that federal agencies use various means, including the issuance of guidance documents, to circumvent various checks on agency rulemaking authority, including the Administrative Procedure Act and OIRA. Is that a possibility or a reality in the present circumstances we find ourselves in?
Sure, thank you. So I think it is too simplistic a claim, and it ignores the fact that, for example, I know a claim was made that a third of rules don't go through the notice and comment process. That's often because those rules are needed for urgent circumstances like national security. That's often because Congress itself has told the agency explicitly, you're not supposed to go through notice and comment rulemaking. Please issue an interim or direct final rule. With respect to those rules, it's that context is necessary. And then I'd also say with respect to guidance documents, there's well-developed authority for agencies to pursue guidance documents when needed. It's interesting to note that, a subset of guidance documents are no action letters, and businesses often request those no action letters expediently and want clarity as to whether a certain business practice is outlawed and will result in enforcement action against them. I don't hear similar concerns from the committee or from my fellow witnesses that those no action letters go through insufficient process and don't result in notice and comment. In fact, Public Citizen actually has been advocating for a notice and comment process for the CFPB's newly enacted no action letter process. Unfortunately, the CFPB has declined to undergo notice and comment where Public Citizen could comment on the results of a no action letter issued by the CFPB. And so that is disappointing in that sense. Public comment, if it's only applied to guidance documents, will result in a basically unfair system with respect to guidance that prioritizes one form of guidance over another. And I'd say the last point I'd make is that I've gone through the various reasons why our regulatory process for notice and comment rulemaking is dysfunctional. It's hard to blame agencies for not wanting to go through that process, although I don't agree that you can just assume that's the intent when agencies issue guidance.
Finally, let me ask you, why does Congress, in your view, delegate broad authority to administrative agencies in the first place?
Well, thank you, Congressman. You mentioned it earlier. For practical reasons, delegation makes a lot of sense. Congress is not able to come up with the minutia and technical details to determine what will be an effective regulation that protects the public. Congress gives broad direction. Delegation is
Inevitable.
Is a model that's followed by the corporate world. It's not surprising that it's followed by our government.
Mm-hmm. Thank you, Mr. Chairman, and thank the witness, and I appreciate all of your testimony.
Thank the ranking member from Michigan, and now recognize the gentleman from New York, Mr. Nadler, for his 5 minutes.
No Republican there? No. Sorry. Thank you, Mr. Chairman. I was waiting for someone on the other side of the aisle to have his 5 minutes or hers, but okay. Mr. Narang, you stated that regulatory agencies, especially in the more important regulations, often miss statutory deadlines. How should we enforce statutory deadlines? Should Congress change the way we write the laws, or is there some other way we should enforce them?
So that's a great question. Thank you, Congressman. Oversight is probably the most immediate and easiest means for Congress to ensure compliance on the front end with statutory deadlines, and then to ensure that agencies are doing their best to get regulations out when they've missed those statutory deadlines. There are other ways that Congress can allow essentially private or third-party enforcement of missed statutory deadlines. This is an important way for citizens.
We would have to put that in the underlying statute to start with.
Yes, that could be that would generally be the case. That's right. But this is one of the best ways for our government to be responsive to citizens that expect the government to protect them.
Let me ask you one question. Give me a brief answer, because I have some questions from other witnesses. When these agencies typically miss the statutory deadlines, is it because they don't like the underlying policy and they're delaying, or is it because we make impossible conditions for them?
Sorry, can you repeat the second? The second case?
The second case, is it because it's impossible for them to meet the unrealistic statutory deadlines that we set up in the first place?
Well, I would say that it depends on the agency, it depends on the circumstances. It's totally justifiable for Congress to want agencies to meet ambitious statutory deadlines for public health and safety issues that are of urgent concern, and there are many of those. And agencies should do their best to prioritize and meet those statutory deadlines.
Thank you. Ms. Harriott, you said you didn't really go into the policy behind the recent guidance on transgender students, but you lambasted the alleged lack of authority in this and similar instances by the Department of Education to issue those guidances. I'm quoting now from a letter, I'm going to paraphrase rather, from a letter from a group called Know Your Nine, meaning the Title IX. In quotes from your testimony, it says, you lambasted the recent Joint Justice Department and Education Department guidance on transgender student rights, declaring that, quote, if someone had said in 1972 that one day Title IX would be interpreted to force schools to allow anatomically intact boys who psychologically, quote, identify, unquote, as girls to use the girls' locker room, he would have been greeted with hoots of laughter, unquote. Harriet's glib dismissal of transgender students' gender identities as nothing more than psychological choices dangerously ignores the high rates of discrimination and sexual violence transgender students face in schools, and glosses over the ways that anti-trans bills limit the students' educational access. So that's my first question of two is, comment on that, please. But my second is, you said that, you questioned, and the quote I just read obviously questions the authority, but the Fourth Circuit recently afforded deference to the federal government's interpretation of Title IX, stating, quote, in the Fourth Circuit decision, the Department's interpretation resolves ambiguity in regulation by providing that in the case of a transgender individual, the individual's sex as male or female is to be generally determined by reference to the student's gender identity, unquote. In other words, the Fourth Circuit said, approved the Department's transgender regulation, in effect, on the basis of Title IX, when you said that Title IX gives no, that this is far beyond the power vested by Title IX.
Okay, on the Fourth Circuit, number one, Fourth Circuit got where it did by saying it was deferring to the Department of Education. That's not something Congress is supposed to do. Congress is actually supposed to be looking at this from the standpoint of what the statute
Congress
actually
writes
means.
laws.
So it's really easy.
No, Congress writes laws. Departments interpret laws. Courts can defer to their interpretation or can say your interpretation is so far out of line that we're not going to defer to it, they're going to knock it down. The Fourth Circuit here says your interpretation is not so far out of line. It's within the permissible parameters of your interpretation, of your interpretive authority, and therefore we will accede to it. That's what the Fourth
And that's what the dissent said was the case, that this was...
dissent, and that's what the case said.
Yeah, but the dissent says that this is, in fact, a misinterpretation of Title IX.
Okay, so your argument is that the Fourth Circuit is wrong. You agree with the dissent.
I agree with the dissent, but I nevertheless say that the Fourth Circuit only could get where they got by deferring to OCR. They're not saying that this is, in fact, the correct interpretation of Title IX.
Deferring, when we write a statute, and of necessity, the executive agency charged with enforcing that statute has to interpret what it means, which it does all the time, the court can say one of three things. The court can say, well, this is obviously right, or the court can say, well, no, this is so out of line that it's obviously wrong, or the court can say, well, this is close enough so that we will defer to the agency's authority to interpret, which is what the Fourth Circuit said here. Now, the dissent says, I gather, from your quote, because I haven't read the dissent says, I gather, that it is so far out of line that we shouldn't defer, that it's just wrong. Okay, so you agree with the dissent, which is your privilege, but to say that the department is so out of line that it's ridiculous, which is the gist of your testimony, is the Fourth Circuit found otherwise.
The gentleman's time has expired, but the gentlelady witness will be allowed to answer.
I got lots of pieces here that have to go in. First, let me just get to some of the other points that were made here. The violence issue and the danger of reading into Title IX something that isn't there. One way that schools have tried to deal with the transgender issues, and I know of no school that has not been sympathetic to the problem here, is by allowing a student in that situation to have some special dispensation, for example, to use the faculty bathroom if that's necessary.
And thus,
The trouble here
and thus
is by
single that
putting
person
Title
out.
IX so that it will treat gender identity as if that is what is prohibited by the statute, will make an action like that illegal. Because students, for example, let's say you've got a female student who identifies male and is being given a difficult time by the other female students, gets to use the faculty bathroom because it's thought that this is simply better for that student. A student now of the same sex but a different gender identity has a reason to object to that and regard that as a violation of Title IX. So what happens is, in dealing with the violence issue, you may in fact have this backfire. That you're going to have more possible solutions that are now illegal under Title IX, less discretion by the schools in order to deal with the subject the way they think is best. And so you got to be careful what you wish for here. You start extending Title IX to include categories that it was never intended to include, and rather than deal with the problem you're trying to deal with, you're going to end up with the problem of more problems, more difficulty in resolving the very issues that you're trying to resolve.
Now the witness's time has expired. Thank you. And now, I recognize the gentlelady from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman. Because there's been so much discussion about the Office of Civil Rights guidance on transgender students, I actually, it caused me to, rather than read the newspaper articles, to read the guidance, which was very instructive. And it really was issued in response to requests for guidance from schools all over the United States, and I think it's very measured in tone. But one of the things it says is on page 2 or 3 that the departments treat a student's gender identity as the student's sex for purposes of Title IX and its implementing regulations. Now, there's a whole line of federal cases that basically have found the same thing, that, and I'm not going to go into them now, but I'll just say this. You know, I don't usually call out witnesses, but here's what the written testimony says, and this is Mrs. Harriet. We are teaching young people a terrible lesson. If I believe that I am a Russian princess, that doesn't make me a Russian princess, even if my friends and acquaintances are willing to indulge my fantasy. Nor am I a great horned owl just because, as I have been told, I happen to share some personality traits with those feathered creatures. I've got to say, I found this rather offensive. And it says to me that the witness really doesn't know anything and probably has never met a transgender child who is going through, in almost every case, a very difficult experience finding themselves. And I believe that the department's guidance will help schools all over the United States in preventing the kind of violence and harassment that these transgender kids find too often. So that's all I'm going to say on that. You know, I think it's very regrettable that that comment was put into the record, and I think it's highly offensive. Now, I'd like to ask you a question, Mr. Narr.
Well, could I comment on that, please?
No, it's just my opinion. You
I
gave
think
your
you'll find that
opinion.
many people find it very offensive that the Department of Education
I think you're a
thinks
bigot,
that they
lady.
can
I think you are an
tell
ignorant
schools
bigot.
all across the country
I think you are an
what they should
ignorant
do.
bigot and anti.
Gentlelady from California will suspend. You're out of order.
She's out of
We don't
order.
call
It's my
names
time,
in this
Mr.
committee, and
Chairman.
you'll not be recognized to do that.
Mr. Chairman, it is my time. And I would just like to say that we allow witnesses to say offensive things, but I cannot allow that kind of bigotry to go into the record unchallenged. Now, I don't want to get into a debate about
Does
it.
that mean you think I am a Russian princess?
I have no idea. I'd like to ask a question of Mr. Naring. I'd like to ask you, sir, you have agreed, I think, that Congress is ill-equipped to engage in the kind of work that agencies perform in these very technical and complex areas. I'm wondering if you have suggestions on how the Congress might approach some of these items, for example, in the science area, that are so complex and yet have a greater direction than has been complained of here today by some.
Sure, thank you, Congresswoman. Science is essential to grounding strong and effective regulation. I think that congressional staffers should generally defer to the consensus, the clear consensus on scientific issues. Where there's ambiguity, I think that there, generally is better left to the agency experts, especially the agency scientists, to make the to make the best determinations grounded on the most up-to-date and comprehensive science and scientific findings. So I think there's a role there for both members of Congress and their staff to pay close attention to what the consensus of scientific findings are, but at the same time, we need to rely on agency scientists when it comes to the difficult questions that require that kind of expertise.
I would just note that I think it's not limited to science. I recently had occasion to reread Section 1201 of a statute, the DMCA, and at the end of the statute, we go on in some precision about beta and VCRs and Betamax and magnetic strips, and you look at it now, it seems laughable that we would have put that in a statute about piracy. Obviously, people are opposed to piracy, but we would have been so much better off had we established goals and then allowed, and instead of technology that became dated and now looks ludicrous.
So I entirely agree. If Congress wants to enact statutes that will stand the test of time, that will be able to address emerging regulatory issues as they emerge, it's better left to the agency experts, and it's better that Congress allow for those gaps to be filled by the experts as circumstances require.
Gentlelady's time has expired, and she yields back the balance. The chair now recognizes the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Ms. Harriet, I think we can agree that the framers of the Constitution were careful not to consolidate government power or governmental power within any one of the three branches of government. Isn't that correct? Mm-hmm. And we would also agree that the framers prevented consolidation of power into any one branch of government by separating or dividing governmental functions between the three branches of government. Isn't that correct?
That and checks and balances. So there's a mixture of powers as well as a separation of powers, but not a perfect separation of powers.
It's actually a diffusion of power between the three branches of government. Wouldn't you agree?
In a sense.
Yeah, it's a check and balance.
Checks and balances, yes.
So no particular power is too concentrated into any one particular branch, so as to adhere to the concept of separation of powers, correct?
With checks and balances.
That's right. And so the checks and balances have been in place since the founding of this great nation, or at least since the passage of the Constitution. You would agree?
Some of them don't work so well anymore, and that's part of why we're here. I think the need to design institutions that have the same sort of checks and balances that the framers envisioned. And for example, I think what we were talking about with Mr. Graham.
Hold on one second. I'm asking the questions. I would like for you to respond.
I thought I was
my
doing
questions. So, are you arguing that we need a constitutional convention or a constitutional amendment to rein in executive overreach? Is that
No,
what
I
you
think
are
we can do
arguing?
it a lot more easily than that.
Okay.
we can do it with the powers that the framers have invested in this branch of government. Isn't that correct?
And I have some proposals for you.
I would hope that one day we would get to your proposals as opposed to having show hearings out of task forces created for political purposes.
My proposals are in my written testimony.
Well, I'm not so much arguing with you.
I'd love to talk about them.
I'm arguing with the body, with my Republican friends who control this body. I mean, I view it as unnecessary to have a task force on executive overreach when the legislative branch has the very power to check and balance any perceived overreach by the executive branch.
And I've got some ideas for you.
Well, do you agree with me that this hearing seems to be unnecessary?
Well, if we turn...
I'll put it like this. What would be a better use of our time is perhaps marking up one of the legislative proposals that are outlined in your testimony. Isn't that correct?
I would love to work on that with you. What I would like to do is try to get...
What we're doing today is basically wasting
You see,
time,
the
aren't
thing
we?
is, what I think is going on here is that we're talking past each other.
Well, we're
Is that
wasting
some of the
time.
Democrats
That's
are
what we're
talking
doing.
about regulations, about rules, and the people that have been invited by the Republicans are talking less about the rules and more about the guidances, the notion that we have certain kinds of methods by which administrative agencies make law, in a sense,
Harriet,
through
you
rule.
you are a
And
Republican
as
yourself,
Mr.
are
Narang
you
was
not?
saying,
Are
maybe
you
the
a
procedures
Republican?
are a little gummed up. So what's happening
you a
is that
Republican,
everything is
Ms.
being
Harriet?
bypassed with guidances, and we need to put some
Okay.
limits
All right,
on
so,
guidances.
Ms. Harriet, I want to move from you and ask Mr. Narang to answer my question. Are we wasting time here, sir?
My response would be that if Congress has a particular problem with a guidance that's not going through rulemaking, pass a law to make that guidance go through rulemaking. If Congress has a particular problem with a regulation, pass a law to repeal that regulation. That is well within the powers of Congress and would be a clear direction to agencies.
Well, and would you discuss Congress's power of the purse as it bears on the issue of alleged executive overreach?
There are many mechanisms at Congress's disposal, the power of the purse, and many mechanisms within Congress's dispensing of appropriations to control perceived executive overreach.
Is congressional gridlock a contributing factor to any executive overreach that may be claimed?
I think it could be.
Do you think it is? In this, given the paucity of legislative action by this particular Congress compared to other Congresses, this one has been known as a do-nothing Congress, if not the most do-nothingest Congress in the history of the nation. Would that bear upon this issue of alleged executive overreach?
So if Congress has passed a law, that law delegates authority in most circumstances to agencies. Agencies use that authority. If subsequently congressional inaction occurs, then those agencies are still more than allowed to use the congressional authority they have to issue regulations that protect the public's health and safety.
Well, Ms. Harriet, I would love to ask you that question, but I know that you will take it off wildly in a different direction. So at this point, I will I will yield the balance of my time.
The gentleman from Georgia returns the balance of his time, and this concludes today's hearing. And I want to thank all the witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. I thank the witnesses, and I thank the members and the audience, and this hearing is now adjourned.